Start. The learned counsel for the defendant number 1 appellants would contend that there was enough evidence on the record to show that the defendant number 1 appellants were in adverse possession of the suit property. Stop. It is further the contention that the defendant number 1 appellants had produced on record an electricity bill and an agreement to sell dated 10 December 2004, which showed their ownership over the suit property by way of adverse possession. Stop. Per contra, the learned counsel for the plaintiff respondents would contend that the plea of adverse possession was rejected by both the courts inasmuch as no date was forthcoming as to when the adverse possession commenced in the present case. Stop. The learned counsel for the plaintiff respondents would further contend that the pleadings are totally bereft of any details since the when defendant number 1 appellants are in adverse possession. Stop. In the present case, the only plea raised by the learned counsel for the defendant number 1 appellants is that they were in adverse possession of the suit property, which stood proved by way of cogent evidence. Stop. Firstly, a perusal of the written statement reveals that there is no date forthcoming as to since when the defendant number 1 appellants are claiming themselves to be in adverse possession. Stop. Though it has been stated in the written statement that they have been in possession of the suit property since the time of their ancestors. However, no pleadings qua the date were stated in the written statement. Stop. Further still, the electricity bill which has been relied upon by the learned counsel for the defendant number 1 appellants to contend that the said bill would show the possession of the defendant number 1 appellants cannot be accepted inasmuch as the said bill is in the name of one Anita, who is not a party to the lies. Stop. In fact, there is not even an averment to this effect that there was any electricity meter in the name of Anita in the suit property. Stop. Though before the trial court no agreement to sell was set up. However, before the first appellate court an agreement to sell dated 10 December 2004 was set up by the defendant number 1 appellants, which was rightly rejected by the first appellate court in the absence of any pleadings. Stop. Third, the plea of adverse possession being essentially a plea based on facts, it was required to be proved by the party raising it on the basis of proper pleadings and evidence. Stop. The burden to prove such plea was therefore on the defendant who had raised it. Stop. It was therefore necessary for him to have discharged the burden that lay on him in accordance with the law. Stop. When both the courts below held and in our view rightly that the defendant has failed to prove the plea of adverse possession in relation to the suit land, then such concurrent findings of fact were unimpeachable and binding on the High Court stop. Fourth, the High Court erred fundamentally in observing in para 7 that it was not necessary for him to first admit the ownership of the plaintiff before raising a such plea. Stop.